This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about first-party property losses and what is required of a claims department after a claim is presented and when faced with a loss report. And we must understand that every claim begins with receipt of a notice of loss. A notice of loss is a written or oral report to the insurer that the insured has incurred a loss. It advises the insurer that it has incurred the loss, the date it would happen, with respect to the insured, whether a basic fire loss, a theft, or even a wildfire to one or more properties, the risk of loss of which was insured. The loss notice will advise the insurer, 1, the name and address and telephone number and or email address of the person most knowledgeable, the date and time of the loss, the location of the loss, the cause of the loss, whether wildfire, flood, earthquake, vandalism, or major theft. After the insurer receives a notice of loss, the insurer is required by the custom and practice of professional claims handling and the requirement of the California Fair Claims Settlement Practices statute and regulations to enforce the statute or similar statutes across the country. The insurer must acknowledge receipt of the notice of loss in writing immediately, but in no event more than 15 calendar days. The acknowledgement letter must also include advice to the insured on the coverage available. To properly acknowledge the notice of loss, the claims person must obtain a complete copy of the policy, read and analyze the policy, and create a summary of the coverages available. California Fair Claims Settlement Practices Regulations Section 2695.4, for example, provides, quote, every insurer shall disclose to a first-party claimant or beneficiary all benefits, coverages, time limits, or other provisions of any insurance policy issued by that insurer that may apply to the claim presented by the claimant. When additional benefits might reasonably be payable under an insured's policy upon receipt of additional proofs of claim, the insurer shall immediately communicate this fact to the insured and cooperate with and assist the insured in determining the extent of the insurer's additional liability. The letter should include as a bare minimum information like 1, the limits of liability of the policy, 2, any deductible or self-insured retention, 3, advice concerning any specific exclusions or conditions that apply to the facts established by the notice of loss, 4, a written notice that a proof of loss is required within 60 days of the letter with an attached proof of loss form, 5, a requirement for the production of necessary documents, 6, a reservation of rights if called for, and 7, any other information the insured needs to fulfill the conditions of the policy. The letter should include, because a wildfire's damages are almost always serious, and because the adjuster realizes that to an individual any claim is serious, and should include confirmation by the claims person of an appointment to meet with the insured to view the damaged property or properties. The inspection should be as soon as possible, but no later than 15 calendar days after the notice of loss. The inspection should include the creation of a scope of loss, and the scope of loss the claims person prepares should be written in the same form as a professional contractor that the claims person has determined is acceptable to the insurer and is professional. The adjusters should contact several reconstruction contractors who are willing to do reconstruction work for detail on the claims person's scope. The adjuster must understand that standard prices in software like those produced by the company's program called Xactimate will change in a catastrophe situation or just depending on location because of the shortage of people and materials available to repair structures. The agreed scope of loss should include all damages incurred by the insured to real and personal property, equipment, stock, merchandise, inventory, appurtenant property, plants, trees, shrubs, etc. The scope of a major loss will often be recorded and later transcribed, especially when there is a major damage in multiple properties and types of property. The scope of a major loss can be multiple pages and supplemented with photos and videos of the loss locations. The scope is not an estimate, nor is it an adjustment. It is an outline of the damages that the insured and the adjuster agree, the items that need to reach a later agreement after a thorough investigation. The full amount of loss can be determined and is commenced immediately, but in no event more than 15 calendar days after the receipt of a notice of loss. A thorough investigation is a thorough investigation if it is conducted for each claim sufficient to allow a determination of coverage, the liability of the insured, the nature and extent of damage, or the obligation of the insurer or surety. An investigation is not sufficient if the work of the claims handler is limited to a mere reading of the policy and comparing it to a loss notice. Once a scope of loss is agreed, it is the obligation of the insurer to obtain estimates from one contractors to construction experts to put a dollar amount on the structure losses. 3, if personal property is involved, the scope details the property damaged or destroyed, and once agreed, obtains estimates from personal property or equipment experts, personal property valuers. If there are time element losses, once the scope of the loss is agreed, the insured and the insurer will work together with a CPA or forensic accountants to establish the extent to which time element losses have occurred, and depending on the record of the loss, it is essential that the claims department work preferably in person in establishing an agreed scope of loss and an agreed amount of loss. Now, the regulations have changed some reasoning by creating what they call a proof of claim. A proof of claim is not a total claim, is not a proof of loss, but is still something very important to every claims handler. The claims person must work closely with the insured to reach agreement as to the amount of loss and damage from the very beginning. Once the insured presents a proof of claim as defined by the California Fair Claims Settlement Practices Regulations as, quote, proof of claim means any evidence or documentation in the possession of the insurer, whether as a result of its having been submitted by the claimant or obtained by the insurer in the course of its investigation, that provides any evidence of the claim and that reasonably supports the magnitude or the amount of the claimed loss, close quote. This is section 2695.2 paren s, close paren. A proof of claim is not a sworn statement in proof of loss required by almost all first-party property insurance policies as a condition precedent to indemnity. Rather, it is something less than a proof of loss, and if the insurer wants a proof of loss, it must demand it in writing in accordance with the policy wording. The insurer must still respond promptly within the time limits set by the regulations to the proof of claim. Failure to do so would be an obvious and clear violation of the regulations. The claims person is not required to accept or reject the claim within 40 calendar days, but must respond to the presentation of the proof of claim either accepting, rejecting, or advising the insured/claimant that the insurer needs further investigation and time to respond to the proof of claim. If investigation is needed to respond to the proof of claim, it is necessary to repeat every 30 days. An explanation why the insurer is unable to respond to the proof of claim and when it expects to be able to properly respond. If the insurer agrees to the proof of claim, the amount stated becomes undisputed and payment is required immediately, but in no event more than 40 calendar days from the date of the proof of claim becomes undisputed. It is the obligation of the claims personnel to work to resolve the claim promptly and as soon as reasonably practicable. The proof of claim is a starting point from which the insurer and the insured can get a total resolution. If they cannot agree, the insured and the insurer have options to assist in receiving and completing an agreed upon amount of loss. The insurer must advise the insured what additional information is needed to conclude the claim. The regulations require that the insurer advise the insured what is needed and how much time it will take them to resolve the claim, and the insurer is obligated to do this every 30 days. Then there's the proof of loss, and unlike the proof of claim, the policy requires a proof of loss to resolve the claim. A proof of loss is usually a means of reciting the agreement between the insured and the insurer as to the amount of loss. If an agreement cannot be reached, once demanded, the insured must submit a proof of loss. After the insured's proof of loss is submitted and received, the insurer must immediately, but no later than 30 calendar days after receipt, its agreement, disagreement, acceptance, or refusal of the proof of loss, explaining in detail the reasons why the proof of loss is not acceptable and what is needed for it to be acceptable and how much time the insurer needs to resolve the claims. The insurer can require as part of the proof of loss that the insured or its employees submit to an examination under oath, which once taken and transcribed can become part of the proof of loss. And once the transcripts are signed and delivered to the insurer, it must respond to the full proof of loss immediately, but in no event more than 30 calendar days. If there's an agreement, money must be provided to the insured immediately, but no more than 30 days after the agreement is recited. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll have access to the more than 4,700 blog postings. Please tell your friends and colleagues about this blog and the videos, and let them subscribe as well. And the videos are also free at YouTube and at rumble.com. And if you view the video, I'd appreciate it if you subscribe. And if you click on the like button on YouTube and the thumbs up button on rumble.com. If you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.